I'm not sure that's satisfactory to me. The way you're defining this, but for now, something could fall apart. So how about an employer strike or an employment dispute of a critical engineer of some sort?
So I guess what I would say about that is it might depend. I mean, here, for example—
Depend on what? That's the problem.
Well, I think it would depend on how—
If we define it as capaciously as you do, I'm not sure what the stopping point would be or how we would limit the application of this case.
Well, I guess I'd ask you to think about it this way. I mean, I would think— I mean, there are provisions in this contract that go to working conditions. Now, here, the contract went out of its way to say that the FLSA should apply here. But if the contract said something to the contrary and a state tried to apply its minimum wage law to the refinery itself, then I think that would be a situation where you would probably satisfy the statute and you could remove—
So, but that, you seem to be arguing that the only defense is a federal defense, which is part of the test, right?
You certainly need a federal defense, and
right.
As Judge Oldham made clear below, I think that's something that does a lot of the limiting work on this statute. And I do think it's relevant to keep in mind here that, obviously this court is concerned about these broad terms and coming up with limits, but the stakes here are a little bit lower in two respects. One, in the ERISA context, for example, or the Airline Deregulation Act context, the relating to is the whole game. I mean, it's going to determine whether state law is displaced. Here, it's just one of 3 or 4 factors, depending on how you count them. And then the second thing is, the net result of this is not that your state law claim is displaced. It's just that you would have to bring your state law claim in a different forum. And
I didn't see your brief taking on the government's position that strongly, but you did so here in your opening statement. And you answered Justice Thomas by saying that the government's position would expand our case law in saying that that regulation alone could give you the nexus. So how would you limit the government's position, that it's not regulation alone, it's regulation plus what?
Well, I guess I would say you could come at it 2 ways. You could come at it and say it's regulation plus close supervision and control as a practical matter, and I think you had this here.
But that's true of most regulation, environmental regulation, for example. So I don't think that standing alone is enough.
Well, so let me give you my alternative theory, which is maybe not to think about it as regulation plus, but regulation to what end? I mean, in Watson, you have the classic kind of more typical government regulation where they're regulating, but they're regulating the provision of a product to a third party. The government's not buying light cigarettes. The government probably, all things being equal, would probably prefer there are less light cigarettes in the world than more. So it's kind of classic, the government as government regulating. These regulations, I think, are better understood as the government as procurer regulating in service of maximizing its procurement objectives. Part of the reason that they're in there regulating the spacing of the drill isn't because they have like some newfound federal interest in drill spacing. It's that they're trying to make sure that they can get material out of the ground quickly, that they can do it in a way that preserves steel, which is scarce during the wartime. And so really all of these various regulations, including the regulation of production, is done in service of procurement. And that's just a very different situation from what this court had in Watson, but it's also a very different situation from the mine run of regulation in all these cases. I mean, there's another amicus brief supporting my friends that goes through all of these federal cases involving poultry, involving nursing homes during the pandemic, and it's an interesting sort of litany of cases. But the federal courts in all of those cases were able to say, no, those stay in state court. And I think if you recognize that the kind of regulation here is distinct in the World War II context, I think that would be one way to reverse the decision below, but still not open up any floodgates.